It's still Saturday, the 6th of March, 2021, and we are now on training video number 2 on how to apply the law. So this video, Mark, is what is the difference between lawful and legal? Over to you, Maestro.
Yeah, okay. This is a very long-going debate, which is caused a huge amount of confusion, and actually still does cause a lot of confusion and is a huge part of the actual problem that we're facing. So I just want to show you what's the difference between legal and lawful. So can you see my screen there, Glenn?
I can indeed, sir, yes.
Okay, this is the government website, legislation.gov.uk. Okay, and this is the landing page. And here it shows you all UK legislation excluding, and when you click down, it fundamentally boils down to two things. You get UK primary legislation, and that includes general acts of parliaments, old things, a whole list. And then you get secondary legislation. Now, secondary legislation derives its authority from primary legislation, and that's called conferred powers. And that's where, for instance, the coronavirus statutory instruments are created. So they are secondary legislation, statutory instruments, claiming their authority from primary legislation, general acts. Now, primary legislation is created by Parliament assembled. So Parliament assembled is the authority and the source of all legislation. They then authorize the government to act, and the government is responsible to Parliament, and you're probably familiar with Parliament question time or Prime Minister's question time. So what's happening there is that Parliament is checking, or should be checking, that the government is doing what Parliament has willed them to do. And hence the government can act illegally by not by exceeding the authority that Parliament's delegated them. So fundamentally, there's only two types of legislation, and obviously the word legislation is very closely associated with legal, and there's again a history to that. So, how do we know the difference? Here is a tab called Understand is the difference. Now, remember, there's only two types, primary or secondary. However, you'll hear many people talk about statutory law, this, that, the other, common law, blah, blah, blah. So Parliament only creates primary legislation. So primary is created by Parliament. So that then inside it will give it its jurisdiction. So here we now go to clear the muddy waters. Okay, these types of legislation are sometimes referred to as statutes, and this term statute book refers to the whole of the statute law currently in force. So what it's saying is just statutes or the statute book. Okay, statutes are merely primary legislation, nothing more, nothing less. Then secondary legislation, like I've said, is delegated, okay, and gains its authority from primary legislation. So legislation equals legal, all right? Now, if we scroll down further on this, okay, there's something called case law. Now, we're talking law as opposed to legal. So case law is set from the rulings from the court judgments, that precedents for how the law has been interpreted and applied in certain cases. And then here's the big clanger, case law is not held on legislation.gov.uk. You will not find any law on here.
Well, that obviously answers the question, Mark, doesn't it? Is we're regularly asked by so many people, not particularly the question, what is the difference between something that is lawful and legal? But most people say, hang on a minute, is it law that I have to wear a mask? Is it law that I have to stay at home? No, it is not. And the question that they ask then is that when does legislation become law, or does it ever become law?
Well, we'll get onto that. And remember in the first video we said, for anything to have the force of law, it must be possible, it must be rational, and it must be reasonable. And that would be determined by a jury. Well, sorry, reasonableness would be determined by a jury. If it's not rational, it doesn't even, it gets thrown out. So,
I think I'm just trying to bring this back down to layman's terms, just to go back to again say that question is most people are saying that even the enforcement people are suggesting, they're not actually saying it, Mark, are they? You know, you don't hear the Prime Minister Matt Hancock or a police officer say you cannot do that because it is law. The law states that you must lock yourself down. No, it does not. The law states you must wear a mask. No, it does not. This is all under legislation, not law.
Correct. And so we'll be looking at, I'll quickly touch on the Coronavirus Act just to show you why it's none of it's legal. Okay.
All lawful.
Yeah, correct. If it's anything can be legal, okay, so they legally grant themselves immunity. But that goes against the law, because lawfully we're all equal under the law and nobody's above the law. Therefore, immunity, for instance, like with the pharmaceutical companies with these vaccines, it might be legal, but it's not lawful. And that's why, if you heard with the case a couple of days ago, that not only Matt Hancock has been unlawful, but so has Boris Johnson, where they've lied. And the obvious question is, well, why is the Crown Prosecutor not prosecuting them?
Yes, there's a question there for you, Mark. Why is the Crown Prosecutor not prosecuting them? Is there some sort of a scamdemic going around at the moment?
Well, it's quite simple, because the Crown Prosecutor works for the government, so the government's not going to prosecute itself, which is why we can bring the cases as private prosecutions.
This is an interesting paragraph, and just to let people know that this wasn't written by someone with dyslexia. This is exactly how they used to write back in those days, isn't it?
Absolutely. Right, so I've shown you already there in the understanding legislation that there's a difference between legal and lawful. So this was the first act of Parliament made after the Bill of Rights, which is where all the authority of those governing today comes from. And if we go down to the bottom, in the last sentence, okay, that all and singular acts made and enacted by the said Parliament were and are laws and statutes of this kingdom. Okay, the kingdom's a legal fiction. The kingdom is basically the people who've subjected themselves to the kingdom. But then it goes on to say, and as such ought to be, okay, reputed, taken and obeyed by all the people of this kingdom. So they're saying the people are separate from the people who fall under this having the force of law. And as such ought to be is exactly what you were saying. Okay, that's advice and guidance. Now, how many times has Boris stood up there and said, this is guidance, this is advice? How many times have the minister stood up there and said, this is guidance, this is advice? So again, they tell you it's not law. However, the question becomes, why did people try and enforce it like the police? So why do the supermarkets try and enforce it? it's very clear that nothing that comes out of Parliament just by this simple, Crown and Parliament Recognition Act 1689, nothing that they push out is law. And we'll be touching on this when I speak about common law, because that's basically based on, is it possible? Is it rational? Is it reasonable? Then it has the force of law. But what's caused a lot of confusion is a lot of the common laws actually being codified into acts of Parliament. And so they don't really know what's the difference. And hence, if anybody comes and says, oh, in accordance with Act of Parliament, blah, 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 you got to do X, Y, Z, you simply turn around, okay? Like we saw in understanding legislation, how has the court interpreted that? Because that's the law. I.e., please provide me with the binding precedents. If they cannot provide you with the binding precedents, they have no authority to continue that interaction.
This is where, as you know, the majority of police officers, when they're out and about and they're talking with people, they say, yes, it's under the Coronavirus Act of 2020. The fact that they call it the Coronavirus Act 2020 almost sounds lawful, and therefore the general public back down as if to think, oh, the Coronavirus Act 2020 has been put into force, and therefore it must be law. Okay,
and we'll look at that because it's law only for certain people. We'll get onto that.
Yeah.
And in fact, that's what we'll get onto next. So here's the Coronavirus Act 2020. Okay, and every act, this is what's called the title page. So let me just take you back to the table of contents of the act. Okay. So what most people don't ever look at is this here, the introductory text. This is the front page, just like a book is. So first thing to know, it says act, okay? Act does not equal law. It's an act, acting, theater. For who is this law though, is written down here, okay? Be it enacted by the Queen's Most Excellent Majesty. The other parties are Lords Spiritual and Temporal and Commons. So these are the actors that this applies to because they've advised and consented to it. So again, advise, consent, this is a common law contract. It's a settlement between these parties, and it tells you quite clearly, by authority of the same. Those are the only people who've authorized and consented to be subjected to this act. Therefore, acts only have the force of law between the consenting parties and not you or me.
Yeah, there's two things I'd just add to that, Mark, is obviously we've spoken many times before about the English language, the English dictionary, the use of words and what words truly mean. And it's interesting there how you brought up again the word act as in an actor. As we've said earlier, legislation, legal. We mentioned the word form, format. When you actually do study the English language, and if you just go back to that page, Mark, a moment, I'll just, and this is where it's so easy to, for want of a better word, dupe people. You know, if you presented that in front of someone, just look at the way it's presented. If you were a layman, you'd go, wow, it's got the Queen's crest, the Queen's crest on there. It's the Coronavirus Act. This is between the monarch, the Lords Spiritual and Temporal. All of a sudden, people think, oh my God, it must be law just by looking at that documentation. As you said, when you simply look at it, on the contrary, if you really did understand what advice and consent meant, if you knew who the Lords Spiritual, Temporal and Commons are, is you could quite simply look at that and do exactly what you've done, which is said, this is just an act. The act is obviously enacted by the Queen, and it's upon the advice and consent of Spiritual, Temporal and Commons, and this present Parliament assembled and by the authority of the same. So this isn't even a dictate to the people.
Correct. Yeah. Actually, I wasn't going to bring the Bill of Rights into this, but I think with where you've taken the discussion, let's quickly have a look at the Bill of Rights, because this is the source of authority of the current actors. Okay. So basically, it starts off, whereas the Lords spiritual and temporal and commons assembled at Westminster, lawfully, fully, and freely representing all the estates of the people of the realm. Okay, so they making a claim there that they firstly, that they lawfully and fully and freely are representing all the estates of the people. Okay, so you need to have a definition of the word estates. What do they mean by estates? Because fundamentally, estates used to be the gentry. Okay, and who are the people of the realm? Okay, so the wording is very important, and I will specifically do something on the Bill of Rights. Sorry, just remind me, Glenn, what you were saying about the interpretations of this, because
yeah, the point that I was making, Mark, is that the way that the general public interpret any document is the fact that if something looks to be something quite, and you could even use the word ominous, if you receive something through the post with the Queen's crest on it, and sort of the subject matter is talking about representation by Lord Spiritual, Temporal, and Commons, etc.
Absolutely. Sorry, I remember now where I was going with this. Okay, so who's the Lord Spiritual, Lord's Temporal, and the Commons? Okay, basically, what this Bill of Rights is a power sharing agreement between the Lord's Spiritual, the Lord's Temporal, the Commons, and at the time William, Orange, and Mary. Okay, it's no more than a power sharing settlement between them as to who's going to do what. And so we need to go back a little bit in history. The Lord's spiritual of the church, which ultimately the monarch becomes the head of. So that's the monarch themselves. But we need a little bit of history behind this, okay? Remember King James's Bible that became the authorized version in 1611. And that there was basically to get the Protestant church. So you had the whole Protestants versus Catholic battles that led up to this. So it pleased Almighty God to make this instrument to deliver the kingdom from popery and arbitrary power. So that was really the result of the battle between the Protestants and the Catholics.
Good old William of Orange.
Yeah, but again, it's misunderstood because here they use the words throne being vacant. The reason it was vacant is because King James couldn't run away fast enough with Orange and the Lords that arranged the getting rid of him. Whoops, what on earth's that?
Oh, there's a pretty picture. Thank you for that interlude. Is this are we having a break there or something?
No, and so basically what they've done is use the words vacant so that they could change the line of the royal bloodline away from the Catholics. So fundamentally, they just got rid of him. Now go back to Magna Carta. What was the difference there? There they held a sword to who was the King Charles, and he signed Magna Carta 1215. Here they just got the soldiers walking in once they landed. King James just buggered off so that there was no sword or that he wouldn't hang. So the Lord's Temporal are basically the security guards, the thugs, looking after the Lord's spiritual, and which is the monarchy. And then the Commons have been given certain rights with this. So while we're here, it might be worth it. Okay, the subjects' rights. Okay, now they define themselves as subjects. These people, anyway, just accept it for now. We'll do an in-depth thing on it. So they're saying this is for the subjects. So the subjects are basically the Lord's temporal, the Lord's spiritual, and the commons, the people, the estated, the gentry, the ones that had the money. And they've given themselves certain rights. So they've separated out Her Majesty or His Majesty's government, basically as far as dispensing power and doing what now, like we saw with the legislation, Parliament creates acts of Parliament, and that's what authorizes the government. And this is where the separation of the powers comes from. Now, people seem to think that the courts actually fall under Parliament. They don't. The only thing in here is that the courts cannot be ecclesiastical, i.e. the church can't run the courts. Further, the government can't levy any money without Parliament saying so. Everybody has the right to petition the king. The king can't raise a standing army. Now here it's very specific. Subject arms is only for Protestants. Okay. However, there's a nice little catch in this whole thing. So same thing, freedom of speech, basically they believe is only for MPs, which is nonsense. Then there were some conditions put on the courts, the judiciary, which was within the control of the monarch. Okay, they can't have set excessive bail, fines, cruel or unusual punishment, and the jurors must, okay, it's a jury, trials by jury, which also comes from Magna Carta, and nothing, no fine, no PCN, no anything, no council tax until it's conviction in a court. So basically what's different in here is somewhere in here you'll see that when the crown was accepted by William and Mary, instead of those being subjects' rights, okay, it became all the people's rights. And therefore we all have freedom of speech. We all have right to bear arms. Let me just find it because that really is quite important. And it's not much more after this anyway. Sorry, bear with me. Okay, here. That all and singular the rights and liberties asserted and claimed in the said declaration, which was above, which had been through, are true, ancient, and indubitable rights and liberties of the people. Okay, so now it's not only selective to the subjects, it's for all of the people. And that there means that all of these rights, right to bear arms, right to petition the king, right to trial by jury, right not to have excessive fines, right not to have cruel and unusual punishments, and right not to have anything forfeited without the crown judgment, it is a right for all of us. These are rights we all can stand on. They're not reserved for some and not others. So that was a little diversion. So back to where I was going is the Senior Courts Act 1981. And Section 49 again talks about different terminology. Okay, this is an Act of Parliament, and now it's talking about law and equity. So we've got Act of Parliament, which we know is merely legislation that's applicable only to the contracting parties, which is Parliament assembled. And here what it says is basically every court exercising jurisdiction in England and Wales, so this is applicable in all of England and Wales, in any civil cause or matter shall continue to administer law and equity on the basis that whenever there's any conflict or variance between the rules of equity and the rules of the common law, the rules of equity shall prevail. Okay, so this tells you the highest law in England and Wales is equity. Now, because Scotland also falls under Northern Ireland, the UK Supreme Court, this actually applies to them as well. And what it says here as well, which is very important, is the courts shall so exercise the jurisdiction in every cause or matter before it, as to secure that as far as possible, all matters in dispute between the parties are completely and finally determined. Okay, now here's the cruncher. And all multiplicity of legal proceedings with respect to any of those matters is avoided. So the courts must apply, and they're legally obliged. It's an obligation, they have no choice. They don't do it, but this here is how you move the courts into equity. So they must, to avoid the same problems reoccurring. Okay, and it's the determinations made in the court under equity. If the existing common law does not provide a suitable remedy, you argue lawful excuse under the rules of equity. And so equity prevails. Equity is the highest law. And everybody says this, okay? And this is a fraudulent misrepresentation going back to 1878, where Jessel, Master of the Rolls, said, "This court is not, as I have often said, a court of conscience, but a court of law." I think I've just shown you the fraudulent misrepresentation. Every single case, if you hold the courts to account, must rule in equity. Equity is conscience. And so anybody that tells you that the courts are courts of law and not of conscience is fraudulently misrepresenting. And I'll explain in a later series, a later video, how to move the court to equity.
Mark, can I just say at this particular point that you know, we've had to be very, very careful about the general viewing of what we're trying to help people with. But I'd like to think that most people will agree that up until actually this particular presentation that you're doing right now, most people would say, I'm not really interested in the law. It's something that's above my head. I think that you've actually just brought that there into not only simplified terms, but something of interest to people, that people can now start to look into the history of how the law, the legal system and the lawful system was put into place. So I hope other people have found it as I have. I found it interesting to go through this with you. We're going to have to bring this particular meeting to a close, Mark. So I'm going to let you wrap this one up. I just want to
finish off with saying equity acts in person, i.e. it's about people, and equity will not suffer a wrong without a remedy. And I think I've shown you the evidence. You can check it for yourself. So it's about how do we get equity? How do we get what's fair and just? And that day we'll be talking about much more in separate videos.
That's great, and I look forward to it. You just want to bring off the screen share, Mark?
Oh, sorry.
And I'll just wrap up this this current meeting. Yeah. So yeah, I'd like to think we've attracted some interest from people here. Obviously, we're going to be doing quite a detailed video, and we'll split it into portions on the original Magna Carta at 1215.
Yeah, it's worth going through those.
We'll have a chat about the Magna Carta 2020. We'll also talk about Article 61. I'm going to call it Article 61 then and now. And people say Article 61 then and now. I'm just like, well, why was Article 61 first implemented, but how are people interpreted today? So that's going to be quite interesting. So I'll just let you finish off with any comment, Mark, and let's bring this one to a close, because it's running into a little bit of excessive time.
A few of the words that I've been using, the most important is really the force of law, okay? And ultimately, it comes down to how do we get anything in force? So the police are coming with bully tactics, for instance, to protest. They're coming in numbers. They're coming to threaten and intimidate, and they're enforcing what. So I didn't even go into it to show you that the Coronavirus Act is actually, you know, it does not meet the criteria of the rule of to have the force of law.
Well, we are going to do that in separate videos.
As
As you know, is that we're going to do literally a 5-minute video on how to approach a police officer, to a police station, to an NHS hospital, to a GP, to a supermarket,
precisely.
to a school. We're going to do individual videos on them all. So great, Mark. See you on the next video.
Okay, cool. Cheers, Glenn.
Thanks. Cheers. Bye.
Bye.